Let's get more now on the landmark decision by a top UN court that's cleared the way for countries to sue each other over climate change. The ruling is non-binding, but legal experts say it could have wide-ranging consequences, and it's being seen as a victory for countries that are vulnerable to rising sea levels and extreme weather. Hannah White is a senior lawyer with Environmental Justice Australia Climate Team and joins us now. Good afternoon to you, Hannah.
Hello, how are you?
I'm very well, thank you. How significant a ruling is this?
Look, to put it simply, this case is historic. It's the first time the International Court of Justice is the world's top court, and they have ruled that countries like Australia have obligations to protect the climate from harm. I think it's really important to note that this came from like a groundswell of young, incredible students from the Pacific, and they have taken this all the way to the top court. So it's historic not only from an international legal perspective, but it's also historic because young people once again, and specifically from the Pacific, are once again fighting for climate justice, and they've won today.
But it is a non-binding ruling, isn't it? So will high-emission countries just be able to ignore it?
That's a really great question. So technically, yes. The International Court of Justice's opinion is an advisory opinion, so it is non-binding. But I think the important thing to note is that governments like Australia have signed up to the treaties that the court says states have obligations to uphold. So it's kind of an expectation that democratic countries will hear what the court has said and now take steps to implement that and make sure that their climate laws reflect what they're obligated to do under international law.
So do you expect then there'll now be a wave of legal action from communities on the front line of climate change, such as Vanuatu, which brought this case, as you've said, communities wanting to sue for compensation or to put pressure on countries to put in place more ambitious emission targets?
Look, if governments do what the court has now said they're obligated to do, I don't expect that there will be this wave of litigation. If governments take steps to cut their emissions, rapidly phase out fossil fuels, and ensure that they're taking steps aligned with the 1.5-degree temperature goals set out under Paris, yet, like I said, I don't expect there will be. I think it's really important to note as well that litigation itself is taxing. It takes years to get up. Working for Environmental Justice Australia with communities on the front lines of the climate crisis, this is their lives we're talking about. And if governments are acting, they don't necessarily have to go to court to hold them to account.
As you say, Hannah, this is an extraordinary win for the law students from Vanuatu who brought the case, real David and Goliath story. They argued their case at the ICJ, which has global jurisdiction. They won. What arguments did they use? Which were the arguments that persuaded the court to rule in their favour?
Look, I think there were probably a variety of different arguments they used. International law is, I mean, the court's judgment, the summary alone was 40 pages. So it's hard to kind of do condense it into a crux. But one thing that I think was incredibly compelling was the evidence, the overwhelming evidence they provided to the court. Pacific nations stood up and told their stories. They told what is, the court, what is happening to them now, and the sea level rise, the bushfires, the floods, the loss to their culture. So I think in that sense, it's really important to note that the overwhelming evidence really played a role in how the court determined their opinion.
So this action has been successful. But just last week, the federal court found that the Australian government didn't owe a duty of care over the impacts of climate change on islands in the Torres Strait. So how do these two cases relate to each other?
So the PABI decision, which was the case determined in the federal court last week, concerned Australia's climate reduction targets, which are the targets they set to reduce greenhouse gas emissions. The ICJ advisory opinion did make comments on the obligations that states have to set climate emission reduction targets, and they emphatically stated that countries like Australia must set targets which align with the best available science. That is exactly what the claimants argued in PABI, so they're definitely related, and I'm sure the claimants in PABI will be thinking a lot about that today.
But the Torres Strait Islanders lost but the Vanuatu young people won. I'm just wondering why there were two different outcomes for basically the same case.
That's a great question. So the case, I suppose, in Pabai, and I didn't work on that, so I can't really comment on the intricacies, but what I will say is that Australian domestic law does have some differences, and they argued under tort law, duty of care, whereas this is more of an international legal obligations under the ICJ. So there's just some differentiations that may have led to those outcomes.
Okay. Hannah White.